In this case, this is case 24-0403. Basically, what we want to do is to ensure that when you testify, that it is your own testimony. And so what I mean by that is that if you're sitting in a courtroom and listening to someone testify, it might subconsciously affect how you testify, that you might hear something without even realizing that this changes your testimony. So what I've been asked to do is called an order of sequestration, which is just a fancy word for describing how we want to make sure that your testimony is your own. So you can't be present when somebody else is testifying, and you're prohibited from talking to them about their testimony, either before or after the fact. And so if this actually gets found over the circuit court, you still don't want to be in a position of talking to them because, again, you can have your testimony influenced by what it is that you hear. And so this is really about fairness and trying to make sure that the process is fair. So, you guys got that?
Absolutely.
Okay. Who would you like to have testify first, Ms. Bucks?
I'm going to call Officer Trevino first.
Officer Trevino, and it's Officer, you can just go back into the hallway and we'll be shortly.
Yes, sir.
Officer Trevino, if I can get you to raise your right hand, so please swear or affirm that the information that you provide to the court.
Yes, sir.
Please proceed. And tell me what your complete name is. So I'll go first and last.
Antonio, Antonio, Trevino, Trevino.
Lessons for Officer Trevino.
Thank you, Your Honor. Officer Trevino, how are you employed?
Meridian Township Police Department.
How long have you been employed there?
6 years.
Were you working on March 14th of this year?
Yes, I was.
In what capacity?
I was night shift patrol officer. Back off service.
Did you have an interaction with Davion Armstrong on that day?
I did.
Can you please explain the beginning of that interaction?
The only brief interaction I had was assisting other units on who's being detained. That was the only interaction I had directly with Mr. Armstrong.
So, do you know why did that interaction with Mr. Armstrong happen on that day?
So we had a victim come in late that night, Mr. Joe Pearson, stating that he had his vehicle stolen at some point that week earlier in Detroit. And during that week, he was on Facebook Marketplace looking for his Chrysler 300. Believed that he had located it on Facebook Marketplace due to matching damage. Came in to let us know that he had set up a meeting with the people selling the vehicle, which was Mr. Armstrong. They had planned to meet at Meridian Township Police Department.
What did you do in response to this information?
Well, we had a units wait at the police department. Mr. Armstrong also showed up, where I believe his girlfriend was with him. At that point, he was detained to begin investigation of the vehicle.
Is Mr. Armstrong here today?
Yes.
Could you please point him out and identify him by a piece of clothing he is wearing?
Yes, sir. This is John right here in the red, black, and white, or red sweatshirt here.
Thank you, Your Honor. May the record reflect that the witness identified the defendant.
See what Mr. Tringle says, Mr.
Officer, how long did you have an opportunity to view Mr. Armstrong?
Probably less than 2 minutes, maybe. Not even.
And what were the conditions at the time that you had an opportunity to see him?
I had been called back to the police department after meeting. It appeared that he was not going to show. I made it maybe a quarter mile up my road, came back when other units said that he had showed up on scene, arrived, and at that point, they pulled him out of the vehicle and he was being detained.
Was it daytime or nighttime?
It was dusk. It was nighttime.
What is it about Mr. Armstrong's appearance that let you know definitively that this is the gentleman you saw at Evidentiary?
I witnessed him with my own 2 eyes. I also have his license photograph as well as his lead information, SRS information.
Personal contact as well as lien information.
Absolutely.
Thank you, Your Honor. Officer Trevino, you stated that you had searched the defendant's vehicle.
That's right.
What did you find while searching the defendant's vehicle?
Located 2 fraudulent bins in the door, as well as a Glock 19 handgun underneath the driver's seat, which was fully loaded with nothing in the chamber, but a full magazine. And aside from that, nothing else, no blade recall.
2 fraudulent bins and a Glock. And right. Why were you searching the vehicle?
So we had determined pretty quickly that it was our victim's vehicle. We had attempted the key fob, which had already been keyed, and we tried the physical key in the door while the vehicle was still closed, and it did unlock the door, as well as our victim had described at that point, matching identical damage, which he had documented on his cell phone prior to it being stolen. It was very apparent that the damage on both the front right bumper, the rear bumper, the interior console, which you can see from the window, as well as a smashed out window in the back left, all matched identical to the vehicle.
Okay. And so you were impounding the car at that time?
At that moment, we had not decided to make an impound on it. We had just tried the physical key. First determined it was our victim's vehicle. At that point, the victim was permission to enter the vehicle.
And then, okay, so just search it.
Correct.
Mr. Buxton.
Thank you. Nothing additional from this witness.
It sounds like cross-examination.
Thank you. Good afternoon, officer.
Okay.
You indicated that you had prior knowledge that Mr. Armstrong would be present at the Meridian Police Office or Police Department that day.
Correct. Assumed information, yes.
Okay, and you received that information from.
Joe Pearson.
And you were not on scene at the time that Mr. Armstrong was approached.
Correct.
So you can't say whether that the gun you located was there prior to being approached, or if it was after.
I couldn't, but the 4 other officers that were there when he was detained could.
Who are those officers?
That would be Sergeant Clements, Officer Citura, Officer Matternack, as well as Officer Isabella Akers. Correction.
Were you the person that discovered the gun?
I was.
Okay.
And to be clear, you didn't conduct a search on the vehicle until after you obtained permission from, in your words, I think, the owner. Is that correct?
Correct, as well as the identical matching damage, which was very obvious that it was in the vehicle.
Were you aware that ownership was in dispute?
But at that time, no, it was registered in name, which is information that we go off of to Joe Pearson.
Which VIN number did you use?
The VIN number, that whatever plate that he originally had on the vehicle came back to a Chrysler 300 with that matching damage, which was pictured in his cell phone.
What did the other VIN number come back to?
It also came back to a separate Chrysler 300 that appeared to be a fake, and it was the incorrect year as well.
And to be clear, you obtained permission from who you determined to be the owner of the vehicle prior to conducting a search?
Correct.
What happened to the vehicle as a result?
So due to the two fraudulent bins that we weren't able to remove while on scene, we impounded that vehicle until either our evidence tech could take care of it, or I don't know who would take care of it after that fact, but we don't want to send it back on the road really. So it was impounded at our moving township and hauled out.
And just for clarification, so two fraudulent VINs. Were there two VINs that are not accurately reported to that car, in addition to the one that is accurate?
Correct. They're both on the inside door of the vehicle, the driver's side door.
Okay, so there's a total of three VINs then associated with this car.
So it was the one that was inside the door, the driver's side door, you open it. The one that's in the front driver's side window, the peak window was also incorrect. Those were the two.
Where did you find the correct VIN number listed?
So in that particular model, it's engraved as part of the under the hood. So we were able to pop the hood and see that it was in fact Joe Pearson's vehicle.
Were the VIN numbers in the door in the front window? I understand there are two separate locations. Were they the same or separate VIN numbers?
As the one that was in the door, you're saying?
Yes.
Correct. They were the same identical fraudulent bins, yes.
Okay. Did you have the opportunity to speak with Mr. Armstrong at any point?
I don't believe that I did, no. I don't think so.
So you don't know whether he had a CPO?
He was Ramsey, I can't remember if it was myself or someone else. I don't know. I had a CPO.
The gun in fact was registered to him?
So again, I don't recall who ran it. I know I was told, but I obviously can't testify what they had mentioned to me.
You didn't have CDL, but the gun was registered.
I don't recall.
Oh, you don't.
I don't remember if it was me that ran the gun or if it was another officer on scene.
What police agency, or had there been a prior report of this vehicle being stolen?
Correct, it was through Detroit PD.
Thank you. And just to confirm, you had no personal interactions with Mr. Armstrong?
Aside from observing him in the backseat, no.
No further questions, thank you.
All right, thank you. Redirect.
Thank you.
Thank you for your time, sir.
Absolutely.
Your Honor, may I speak, please?
Is the other gentleman right outside the door?
Yes, he is, Your Honor. We will call Officer Alex Statura.
Alex, if you would come all the way around to the witness chair.
Yes, sir.
Just before you see it, if I can get you to raise your right hand. You swear or affirm that the information that you provide to the court will be told.
Yes.
Please have a seat. Thank you very much. Yes, yes. Would you please tell me your complete name and spell both of those last name?
It's Officer Alexander James Statura.
And how you spell Alexander?
ALEXANDER
And Shura?
STACHURA.
Question for the officer in the Virginia Township.
Yes, sir.
Thank you, Your Honor. Officer Statura, how are you employed?
I'm employed at the Virginia Township Police Department.
How long have you been employed there?
Since March of this year.
So were you working on March 14th of 2024?
Yes, sir, I was.
Did you have an interaction with Davion Armstrong on that day?
Yes, sir, I did.
What capacity?
I interviewed Mr. Armstrong and eventually placed him under arrest and transferred him to King County
Where did you have this conversation with Mr. Armstrong?
in Virginia Township Police parking lot.
Is this in regards to a potential stolen vehicle?
Yes, sir.
When talking to Mr. Armstrong, did you review his Miranda rights?
I did.
And did he understand those rights and wish to continue to speak with you?
Yes, that's correct.
What did Mr. Armstrong tell you in regards to the gun that was found in his vehicle?
Mr. Armstrong relayed to me that he was open carrying. He said he retrieved it from his trunk and he was carrying it on his person as defense while he was selling the vehicle at the NTP parking lot.
Did you ask him if he had a CPO?
I did.
What was his statement?
He stated he did not.
He admitted it was his gun.
Yes, sir, that day.
1 second, Your Honor. Nothing further, Your Honor. Thank you.
Observations about the gun.
I did lay eyes on the firearm, Your Honor. That was Officer Trevino.
All right, so you.
Yes, yes, sir.
Mr. Roach.
Good afternoon, officer.
Yeah, amen.
Were you aware that, did you have knowledge that Mr. Armstrong was to meet the alleged owner of the vehicle at Meridian Township Police Department that day?
That was my understanding.
Isn't it true that when Mr. Armstrong was approached, he was advised that it's because he had a firearm on him?
I was the last unit on scene. I did not see Mr. Armstrong until he was in the back. He was detained in the back of an NTP cruiser.
There was a plate on the vehicle, correct?
And that's what I have.
You don't recall?
I don't recall.
You don't recall whether, do you recall whether Mr. Armstrong had a title?
Mr. Armstrong did provide a title.
To your knowledge, he was not issued a citation for improper registration or,
To my knowledge, that's correct.
okay, and in the general course of things, had there not been a plate or registration, that's a citation that would be issued?
Yes, correct.
Thank you. you indicated that you interacted with Mr. Armstrong, correct?
Yes, ma'am.
And you know why the vehicle was searched?
The firearm located in the vehicle.
A firearm located in the vehicle prior to it being searched?
I don't know, I did not perform a search on the vehicle, that was related to that scene.
Do you know who made the decision to search?
I can't say specifically, I was going to be officer, you know.
And Mr. Armstrong, you Mirandized him prior to speaking?
I did.
Okay, and he understood those rights?
That's correct, ma'am.
And wanted to talk to you?
Yes, he waived the rights, yes.
And what was his demeanor at that time?
I remember pretty vividly, Mr. Armstrong was very forthcoming. He allowed us to look through his phone regarding the purchase of the vehicle. I believe he said he purchased it in Detroit. I can't remember specifically, but yes, his demeanor was, you know, very cooperative.
At some point was he informed that it was alleged the vehicle was stolen?
Yes.
And how did he respond?
Good job.
It was your understanding that he had made the arrangement to appear at Meridian Township Police Department to sell the vehicle to the alleged true owner?
That is my understanding, yes.
If you know, who made the arrangements to meet at the Meridian Township Police?
I believe the buyer and Mr. Armstrong agreed to come to MTPD parking lot for the sale of the vehicle.
Interesting.
Like Steve.
And at the time you spoke with Mr. Armstrong, he was not under arrest?
Not at that time.
Because I believe sort of points to me a different question. So at what point did you Mirandize him? Was it before you began speaking to him or after you began speaking
Mr.
to him?
Armstrong was in the back of my supervisor's cruiser, sir, and I was instructed to Mirandize Mr. Armstrong. And once I Mirandized him, he understood his rights and he waived his rights and so forth.
And that's when you said he was very forthcoming.
Yes, sir.
So this was before this was after he was placed in the car.
Yes, he was detained.
That wasn't clear at first. Ms. Tran?
Do you know why he was detained?
It was my understanding that the call came out of the youth complaint. So he was detained via our supervisor, Jason Clements. He's in the back of his vehicle. I was instructed to Mirandize Mr. Armstrong at that time when I got seen.
And when Mr. Armstrong spoke with you, he indicated he purchased the vehicle
That's correct.
in Detroit,
I believe it was Detroit.
Okay. And it was his intention to sell the vehicle that day.
That is correct.
At what point were you involved in determining who the alleged owner was in this matter?
No.
In distinguishing whether it belonged to Mr. Armstrong or Pearson?
No, ma'am.
And did you discuss the firearm with Mr. Armstrong?
I did.
And that's after the car was searched,
Yes, correct.
and you're not sure who made that determination?
No.
Okay. So essentially, he was taken into custody, or detained rather, in suspicion of a
That's correct.
Did you say you?
I'm sorry, unlawful driving away of a motor vehicle.
Okay.
Thank you. Okay. And he presented evidence of ownership.
He did.
He did not consent to the search of the vehicle.
I can say.
Objection. I would say, speculation is, we've not heard any foundation in regards to Mr. Satura knowing the reasons.
Examination. She's not trying to establish a foundation. She wants to ask him what she believes to be a relevant question. So the question is basically, what was the basis for the search? So what you're asking.
Yes.
And so the question was, did he give you permission to search it? And I think you said no.
I can't remember if he did or not, sir.
Okay.
Do you know if Mr. Armstrong spoke to any other officers that day?
Yes, he spoke with myself, obviously, and my training officer at the time, Officer Mandernack.
Okay. Did you speak with Officer Mandernack, before, after you, or at the same time?
At the same time, yeah.
So you would have heard anything that Mr. Armstrong said?
Yes, unless I was getting stuff out of the vehicle or anything like that. My vehicle, my vehicle.
And had you given you consent to search the vehicle, would you have noted that in your report?
Yes.
Okay. I know you indicated previously that you couldn't recall specifically, but if I were to give you the report, could you review it? Permission to approach.
So that's the-
I'll have you read over that to refresh your recollection when you finish. you. Was that refreshed your recollection?
Yes, ma'am.
Okay. And did at any time Mr. Armstrong give consent for the search of the vehicle?
Apparently not.
You also mentioned that he was pretty forthcoming in terms of showing you his phone. And when he showed you the phone, he was showing you messages that related to the purchase or the sale of that vehicle.
Correct.
Okay. And isn't it true that Mr. Armstrong, if you recall, had made the suggestion to meet at Meridian Township Police Department?
Yes.
Thank you. Do you know why Mr. Armstrong made the suggestion to meet at Meridian Township Police
I
Department?
do not know the reason.
No, that was speculation.
I believe you indicated that Mr. Armstrong purchased the firearm that day.
That was what, yes, I got a purchase permit from that day.
So he had legally obtained it.
Correct.
Did you witness a lock, a firearm lock?
No, ma'am, I never really asked him that actual fire myself.
At some point, did Mr. Armstrong advise you that he'd had the firearm in the trunk?
That's what he released, yes.
And the firearm being located in the trunk, that would have been the proper way to transport it?
And locked and independent of ammunition, yes, that was explained to Mr. Armstrong.
No further questions, thank you.
All right, thank you. Austin, do you want-
Nothing additional, Your Honor. Thank you.
Thank you, sir. Appreciate your time.
Thank you very much, Your Honor.
Any further witnesses?
No, Your Honor.
Witnesses or the defense? Okay, let's go to argument. Jury instruction.
Correct, Your Honor. The alternative would also be 11.1A.
Yes.
So, Your Honor, under this case, the people have charged the defendant with carrying a concealed weapon, and we believe that we've met our burden in this case, and we ask you bind over on the charges in the complaint. As I stated, it is currently charged under the jury instruction for 11.1A. However, there is also the carrying concealed weapon jury instruction 11.1. I'm going to go over the jury instruction for 11.1A first, as that was what it has been charged with. However, I will also, in the alternative, go over 11.1. The first element for 11.1A states that a pistol was found in a vehicle that the defendant was in. You heard from Officer Trevino that on March 14, 2024, at the Meridian Township Police Department, the defendant arrived on scene in a vehicle. You heard that Officer Trevino searched said vehicle and found a pistol underneath the driver's seat of that vehicle. Therefore, we have met element 1. Additionally, element 2 states that the defendant knew that the pistol was there. You heard today from Officer Stachura that the defendant admitted to buying the pistol prior to the deal and knew that the pistol was in the vehicle at the time because he himself put the pistol in that location. The third and final element is that the defendant took part in carrying or keeping the pistol in the vehicle. Once again, you heard from Officer Stachura today that the defendant admitted to keeping the pistol inside of his vehicle and putting it underneath the driver's seat at the time. Additionally, Your Honor, I understand that the defendant is arguing in regards to where the pistol was prior to exiting the vehicle. In that case, Your Honor, the defendant is still admitting to carrying a concealed weapon on his person. The defendant knowingly carried a pistol. You heard that Officer Stachura talked to him, and he stated that he did knowingly carry a pistol at the time and put the gun under his vehicle when the officers arrived. Second, that the pistol was concealed on or about the person of the defendant. You heard that he had the gun at the time and decided to hide it from the officers and put it underneath his driver's seat when they arrived on scene. Therefore, under either jury instruction, Your Honor, I believe that the defendant, we've met probable cause in this case, and we ask you bind over on the charges in the complaint.
Thank you, Your Honor. The issue here is a unlawful search. Mr. Armstrong was a good faith purchaser of value of the vehicle.
BFP, I haven't heard that phrase in a long time.
He had a title.
Okay.
He had in fact registered this car with the state of Michigan and it was properly licensed. He had no knowledge that the vehicle had been previously stolen. My understanding that the improper VINs, which we probably learned were the improper VINs on both the windshield and the door, matched the information that my client, Mr. Armstrong, had. For the police to make the determination at the time that the other party was the owner and to seek consent from the other party, or from the other party to search the vehicle, particularly when they knew that Mr. Armstrong had been the one in most recent possession, was claiming ownership. I think they knew it was improper. I think that they very easily could have asked Mr. Armstrong for consent to search the vehicle, and they failed to do so. Additionally, as to where the gun is located, I think that remains a question upon where the gun was located at the time Mr. Armstrong was initially approached by the police. we did not have an officer today who had been there from the beginning. Neither officers, the first officer indicated that he had already been taken out of the car and was asked to search. He doesn't know where the gun was located prior to that. He doesn't know if the gun was located in the trunk prior to Mr. Armstrong's interaction with
We
police.
still have a problem though. Let's say, assuming that is the case, when you still have a problem if it was in the trunk and was loaded, that the magazine was still inside of it with live rounds, even if it's not chambered, when you still have a truck, problem because it's not properly secured that way.
If we could get to that, perhaps. However, I think that we don't even get that far given the illegal search. We don't have the consent of Mr. Armstrong to search the vehicle. We have a consent of the assumed owner, despite the plate that was on the vehicle, the registration, the title that Mr. Armstrong had in his possession. I think it's also notable that Mr. Armstrong had, as the officer indicated, the second officer indicated, had arranged himself to meet at the Meridian Township Police Department. It was his suggestion to meet there so that this transaction could take place in a safe place. Mr. Armstrong had intended to sell a car. A vehicle of that caliber is obviously worth a substantial amount of money. I think it's apparent that Mr. Armstrong was carrying potentially for this, well, not potentially, for the purposes of protection. So I also believe we have a Second Amendment argument as well as it relates to whether even a statute's applicable.
So you think that the CCW law should be unconstitutional?
Frankly, I think the way that the CCW law is written, it prevents anyone from reasonably carrying a gun for purposes of self-defense. No person or no criminal is going to hang on 1 minute while I go to the trunk, get my firearm, load it, right? And frankly, they don't care. True criminals don't care if they're complying with the law. Their felony firearm will be dismissed as part of their plea agreement to the home invasion or whatever it might be. And frankly, I think people are more vulnerable in their vehicles than they are at their home. I know that I think I find it interesting that Mr. Armstrong was able to legally purchase the gun that day. He had no prior convictions that prohibited him from purchasing, and it's essentially a logistical key. Also,
Well, if he was on his way home, that might be an argument that you can make, but on a detour, you had purposely come to the police station to engage in a transaction with Mr. Pearson. The other thing that's problematic from your perspective too is that Mr. Pearson had the apparent authority to be able to give the officer permission to search. Does Mr. Pearson look like the person who had been the victim? He seemed to have the issue of having, well, this is my car, this is all the damage that's on my car, I can positively identify as being my car. And all of those things were untrue. So he gave permission, or they did that at the point that they were taken into impound. I guess it doesn't really matter at that point. Inevitable discovery. And so once Pearson gave them permission, they had good faith to believe that they had permission to search the vehicle. So that's really what the problem with the argument is at this juncture.
Well, I will then also assert that we don't have an officer here that can indicate that or affirm that Mr. Armstrong had during the initial approach, he had the firearm under the driver's seat at the time. Frankly, I'd submit to the court that if Mr. Armstrong had carried legally, retrieved.
Can't carry legally if it's loaded. When it's loaded.
We don't know the condition of the gun when it was removed from the trunk. Probable whether it was loaded, whether it was locked, or whether or not Mr. Armstrong did those things subsequent to removing it from the vehicle.
Oh, remember, we're just looking at the jury instruction. The jury instruction doesn't speak to operability at all.
With that being said,
It's tough. I'm just wondering, it seems to me that they could have charged him with UDAP, but they didn't. And I think that that's probably the thing that they didn't, because there's a whole lot more complexity with respect to this, and the situation like which he finds himself in. It's almost kind of understanding that I don't know that I would know what the rules are with regard to how you carry the gun that you did purchase. I think probably 90% of people that purchase guns don't know what the rules are unless somebody at the gun store tells them what the rules are. But certainly by the time that he had made arrangements to meet at the police station, it was consistent with him just taking it home, that he actually had indicated, I think it was to the second officer, that he was actually carrying it for protection as he was going to the transaction, as opposed to just taking it home from the purchase. So that's problematic too.
I believe that is where the Second Amendment argument comes in as well, because the fact suggests that it would be reasonable for him to want to carry for
We
self-protection.
have to get into statistics and talk about things like what's the rate of crime, and this is a high crime area at the police department and things like that. But I leave to your ingenuity, but I think, well, let you go.
One last.
Yes, ma'am.
So I think also essentially there's a question, and it hasn't been established because there was not an officer presented here today that would indicate that the gun was in the same place that it was found while it was being transported. There wasn't an officer here today that could testify to the fact that the gun was initially discovered, we'll say, under the driver's side seat rather than subsequently placed there after he retrieved it from the trunk. Obviously, being at a police station. Yes, I apologize.
Just thank you for what it was that you just said, trying to figure out logistically how that works with life.
It is my understanding that, well, as the officers indicated, when arrived on scene, he searched the vehicle, found it under the seat. However, he's unaware of what happened prior to him appearing on scene.
That's Officer Davion. You don't know if somebody else took it out of the trunk and put it under the seat, is what you're saying.
Correct. Whether that be the defendant And frankly, assuming that that's true for a moment, when Mr. Armstrong is in a police department parking lot and gets approached by police officers, I'm not sure what other rational response he may have other than to put his gun down, wherever it might be. You don't want to be holding a gun in front of a police officer. So, yes. So while the fact that it may have been discovered under the seat, and yes, had it been transported under the seat, perhaps it would be a CCW, but we don't have anyone here to say who actually witnessed the entirety of the event from start to finish to see where the gun originated from. Based on those things, we would ask, well, all of those things, we would ask that the court not bind over on the carrying concealed weapon charge, as Mr. Armstrong submits that he was carrying properly and only concealed the gun unintentionally, but for purposes of disarming himself as rapidly as possible as police approached, not to hide it, rather for safety purposes of everyone involved, including himself. Frankly, Your Honor, if he would have remained outside the car with the gun, right, in his hand, it would have been lawful because that would have been open carry. But at the same time, it would have been far greater of a risk that he could have ended up shot. He could have hindered, or it could have resulted in him being shot if he were to maintain physical possession of a firearm rather than to just drop it in the car and put his hands up. So we would submit to the court that under the circumstances, there's really not enough to suggest that Mr. Armstrong was carrying a concealed weapon. Additionally, we would suggest that the search of the vehicle was unlawful. And finally, we would submit that as applied in this case, if the court, or if he were to be found guilty of carrying a concealed weapon, that it would be in violation of the Second Amendment rights.
All right, I'll address all three of those points briefly. In regards to the actual search of the vehicle, as you yourself stated, there's apparent authority from Mr. Pearson that this vehicle is his. The damage matches up with exactly the same damage that was on his vehicle. Mr. Pearson used his key, and that key was able to unlock the vehicle. When they ran the proper VIN number on this vehicle, it was Mr. Pearson's vehicle. There's an apparent authority of Mr. Pearson, so there's no problem in regards to the search. In regards to a Second Amendment argument, Your Honor, that's what a CPL is for. And as you heard from Officer Sachira, he talked to the defendant if he had a CPL, and he admitted that he didn't. Finally, Your Honor, in regards to whether the gun may have been moved or not, that's ultimately what that's the defendant's story. That is a question of fact. That is a question of credibility for the jury to make at the time of trial, Your Honor. This is a probable cause hearing. It's clear that the gun was found underneath the driver's seat, and the defendant admitted to having that gun. So, Your Honor, I believe we've met our burden, and we ask you to bind over. Thank you.
All right, 11.1. When carry the pistol. And I should also, and sometimes I don't do this, and I should do it, but the jury instructions are not the key to what it is that I'm supposed to decide. What I'm supposed to decide is whether the defendant is properly charged with an offense. And the standard is basically some evidence as to each element of the offense. So it's not even finding guilt with the this is just finding it's not really to suggest that it should go to trial. So we look at the jury instruction because it has elements of the offense. Go back to that. First, the defendant normally carried a pistol, and it doesn't matter why the defendant carried a pistol, whether it's for personal protection or citing his constitutional rights or whatever. It doesn't matter why he was carrying it. Just that he knew that he had the pistol, and he knew that he had the pistol based on the testimony of the officer that that was his pistol, and that it was under the seat on which the defendant had been seated. Second, the pistol was concealed on about person of the defendant. The pistol is not required. The pistol was concealed if it cannot be seen by those who come in. Actually, you look down at number 4. That having the pistol in the vehicle is enough to be considered concealed. And again, the defendant knew that it was there and that he took part in carrying, keeping the pistol in the vehicle. So, it's really sort of simplistic in terms of instructions. So you probably don't work on that like this because properly charged and charge appears proper. We'll just have to see what happens based on the circuit court. Is there a plea offer placed on the record?
Your Honor, yes, the offer is as charged under HYT and deferral.
Is that a correct statement of what the offer is?
That is my understanding.
Does that offer continue into the court?
That offer does continue in the circuit court, Your Honor.
Any questions with regard to bond?
No, Your Honor, thank you.
$2,500, 10%. I will continue the bond. I don't know that there's ever been a problem with Mr. Armstrong showing up for court. He's actually been anxious to get this matter taken care of, and he's been very, I think, promptly coming forward and trying to make sure that this is taken care of. So I'm going to continue the bond at this point. For the people.
No, Your Honor, thank you.
For the defense.
Nothing further, Your Honor. Thank you.
All right, then that's going to conclude things on this matter. And thank you for your time.
Thank you, Your Honor.
We'll talk this question. I'm actually going to go to lunch. I don't know what Mr. Yang is doing.
Your Honor, just a brief comment.
Oh, okay, well, you're
Thank you, Your Honor.
okay.
Thank you.